Welcome to today's discussion, Marital Property Regimes in South Africa, Marriage in Community of Property. This presentation is proudly brought to you by Schoeman Law Incorporated. We are a boutique law firm based in Cape Town, South Africa. We specialize in serving the needs of the entrepreneur. For more information about us, feel free to watch our About Us video on our website at www.schoemanlaw.co.za. I am Arinda Truter, and I'm grateful for this opportunity to present to you today. I'm an attorney of the High Court of South Africa, notary and conveyancer. I'm a junior associate at Schoeman Law Incorporated, and I specialize in commercial law, contract drafting, triple BEE advice and planning, property law, drafting of wills, and the administration of deceased estates, as well as civil litigation. Please note that this presentation and its slides are copyright protected. Accordingly, this presentation and its slides are only being shared today for educational purposes, and it does not constitute legal advice. Should you require legal advice, or should you be interested in learning how today's topic could be impacting you or your business, feel free to contact us for a consultation. Our contact details can be accessed at www.schoemanlaw.co.za. Please navigate to the Contact Us page for more information. In South Africa, we have two main matrimonial property regimes: marriage in community of property and in community of profit and loss, and marriage out of community of property. Marriage out of community of property can either be with the application of the accrual system or without. This will be discussed in a further presentation. It is important to remember that in terms of the Matrimonial Property Act, the automatic matrimonial property regime in South Africa is the marriage in community of property, unless it is specifically excluded by entering into an antenuptial contract prior to the marriage being solemnized. The legal consequences of a marriage in community of property is quite vast. All assets belonging to the spouses prior to getting married and all assets that they accumulate during the marriage will fall into the joint or communal estate. This includes gifts, donations, inheritances, and remuneration. However, any asset that is donated or bequeathed to a person on the specific condition that the property will not form part of any joint estate by marriage or accrual will be excluded. The same principle applies to liabilities. All liabilities incurred by the spouses prior to and during the marriage are considered the liabilities of the communal estate. This basically means that each spouse owns a 50% undivided share in the communal joint estate, all assets and liabilities. Each spouse has equal management of the joint estate. However, both spouses must consent in writing to transactions involving the disposal of assets of the communal joint estate and contracting of debts by the communal joint estate, also the performance of juristic acts, and any litigation against a third party. Sequestration of the communal joint estate effectively means that both spouses are declared insolvent. The losses of either spouses are considered the losses of both spouses, and should a creditor of one party come knocking, both parties' assets are executable. Upon death of either spouse, the communal joint estate is administered, leaving the spouse unable to access the funds held in the communal joint estate. The administration process can take anything between 12 and 36 months to complete. So what are the advantages and the disadvantages of this system? Obviously, you don't have to enter into a special contract before being able to get married. This can save on some of the marriage expenses. If you are the financially weaker spouse, you get to share in the assets of your spouse. But when you are the economically stronger spouse, you have to share your assets. It is important to remember that a business owned by either spouse falls into the joint estate. and it should be considered how this business will be shared equally in the event of a possible divorce. In this system, you are jointly liable for each other's debts and liabilities, and as already mentioned, sequestration will mean both parties are insolvent. If one party takes a big financial risk that does not pan out, the other spouse will also bear the brunt thereof. The joint administration of a communal estate can be rather complicated, especially when a marriage starts to fail. It can become difficult to obtain joint consent. From a legal perspective, a marriage in community of property deprives both spouses and the children of those spouses of the protection of assets that a marriage out of community of property could have provided. The disadvantages outweigh the advantages in this case, and a marriage without an antenuptial contract exposes you to unnecessary risks. We believe prevention is better than cure. Thank you for joining us for this presentation today. We would love to connect with you. If you have any questions regarding this discussion, or if you need any further advice, we offer several options for consultations. Please feel free to contact us at any of the details listed on this slide. Also, should you have any suggestions regarding future topics, feel free to email us at inquiries@schoemanlaw.co.za. We look forward to connecting with you again soon.